Hi everyone, my name is Bryan Puffolks. I'm an immigration attorney with Puffolks Law Firm. My firm is located in New York, but we do serve clients throughout the 50 states as well as in many areas around the globe. Today I'll be discussing a very important recent decision that can be of tremendous help to you if you're in deportation proceedings. But before we get started, please take a moment to like this video and also to subscribe to this channel for future content. So let's get started. If you're in immigration proceedings, what that means is the Department of Homeland Security is making allegations that you are not legally present in the United States, and they're asking an immigration judge in immigration court to issue a deportation order against you. And you, on the other hand, are making legal arguments to the court on why you have a legal basis to remain in the United States. At a trial, otherwise known as a merits or individual hearing, the judge will decide who made the more persuasive argument and will issue an order, either granting you permission to remain legally in the United States or issuing a deportation order against you. Now, before you get to a trial, while your case is pending, there may come a time for very valid reasons that you would like to put your case on hold, where you don't have to go back to a hearing. You just like to have your case suspended for an indefinite period of time. A term for that is called administrative closure. However, until this recent decision was rendered on July 15, 2021, the case is Matter of Cruz-Valdez. The courts, the immigration courts, and the Board of Immigration Appeals had no authority to administratively close your case. So even though you had very valid reasons to administratively close your case, the courts had no power to grant that wish. This inability of the immigration courts or the Board of Immigration Appeals to administratively close your case is a relatively new thing. That's because Attorney General Jeff Sessions, one of the attorney generals under President Trump, decided the case Matter of Castro-Tun. Matter of Castro-Tun took away the power of administrative closure from the immigration judges as well as the Board of Immigration Appeals. As I stated earlier, there are many valid reasons why you might be seeking administrative closure. Let me give you 5 common reasons. 1, you're the beneficiary of a family petition or an employment-based petition, and USCIS needs time to decide the petition. So you ask for administrative closure to give USCIS time to decide that petition. 2, you submitted a petition on your own behalf to have USCIS classify you as a special immigrant juvenile visa, or because you were the victim of abuse by your U.S. citizen spouse or a lawful permanent resident spouse. In either case, you'd like to have deportation proceedings administratively closed while USCIS is deciding your self-petition. 3, you're planning on submitting to USCIS a provisional unlawful presence waiver, otherwise known as an I-601A waiver. However, USCIS will not accept that waiver application if you're in removal proceedings. So you would like your removal proceedings administratively closed while USCIS decides your 601A provisional unlawful presence waiver, which, if granted, would give you a path to legal status in the United States. 4, you may be appealing a criminal conviction in criminal court, and you'd like the immigration court to have proceedings administratively closed while the criminal court decides your appeal. And finally, 5, you may feel that you don't have the strongest case in the immigration court, and you're not an enforcement priority, so you may want the court to administratively close your case and to focus on higher priority cases. These reasons for wanting to have your case administratively closed is not intended as an exhaustive list. These are just some of the more common reasons that I encounter. So the great news, after approximately 4 years of not being able to have your deportation proceedings administratively closed, the immigration courts and the Board of Immigration Appeals once again have authority to administratively close your case. Now, just because you may have the ability to have your deportation case administratively closed does not make it a good idea. You definitely want to speak to a qualified immigration attorney before making that decision. You can contact me or an immigration attorney in my office if you're interested in a consultation. We can go over the details of your case and determine if administrative closure is a good strategy in your case. A few quick things about administrative closure. Administrative closure is not the termination of your proceedings. It's just putting your proceedings on hold. It doesn't stop the fact that the government has allegations against you that you're not legally present in the United States. If you're looking to beat the government and win your case, you'll have to have your administratively closed case recalendared so that you can seek a favorable decision from the immigration judge. Another thing to keep in mind is that the immigration court may be administratively closing your case to give you time to complete some particular action. And if you don't complete that particular action, the immigration court may view that negatively. And third, you have to remember that it's your obligation to always keep the immigration court updated on where you live. So if your case is administratively closed, even if it's administratively closed for many years, no matter when you move, you have to let the court know immediately your new address. So this takes us to the end of the video. I hope you found the content helpful, and if you did, please take a moment to like the video. I can tell you my office is very happy about this change in administrative closure, and you should feel free if you have any questions about your case. Thank you and have a great day.